aids many victims of sexual violence and provides an additional avenue.
Good afternoon and welcome everyone to the third webinar of our digital dialogue series on the progress and challenges of national efforts to address impunity for sexual violence in conflict. I'm Chloé Marnet-Bassanger and I'm the team leader for the UN team of experts on rule of law and sexual violence in conflict. Today's conversation will be focusing on the impact of sexual violence committed in the context of terrorism, the challenge and opportunities for criminal prosecution and access to justice for survivors, and the definition of justice for victims. In the last years, sexual violence, abduction, sexual slavery, and forced marriages perpetrated by Boko Haram, for instance, have led to collective indignation and call for justice. In 2016, Resolution 2331 of the Security Council specifically recognized that acts of sexual violence and gender-based violence in conflict could amount to a tactic of terrorism, notably by creating incentive for recruitments, supporting financing, destroying, subjugating, or controlling communities, displacing population, extracting information from male and female detainees, advancing ideology which include the suppression of women's rights. The Security Council condemned those acts and recognize the importance of collecting and preserving evidence related to such acts to ensure accountability. While this call for action has been echoed by many today, justice for sexual violence in terrorism contexts has remained elusive, and national judicial systems remain unable to provide the necessary redress for thousands of victims who have survived and returned to their community, and in many cases, face prejudices for having been associated with terrorist groups. So the question we would like to address and discuss and reflect on today is what can and what should justice look like for these survivors? We're joined today by 5 leading experts whose work and experience may allow us to find some answers to this question. And to guide this dialogue, I'm delighted to introduce you to the Special Rapporteur on the Promotion and Protection of Human Rights and Fundamental Freedoms in the context of terrorism, Ms. Fionnuala Ní Eoláin. Fionnuala, the floor is yours.
Thank you, and I'm really delighted to join you all for this conversation, a really important and timely conversation. And I'm grateful to Chloe and to the organizers for putting this event together, bringing this group of experts together, and for the really vast audience that has joined us today. I'm also pleased to join you in the context of my work as Special Rapporteur, which is committed to gender mainstreaming and bringing a gender perspective to all the work that I do for the mandate and elevating the gender consequences and the gender challenges in the counterterrorism arena. So I'd like to start by giving the floor to our first panelist, Azadeh Mouveni. Azadeh is currently the Director of the Gender and Conflict Project in the International Crisis Group. Azadeh has worked across the MENA region for over a decade as a correspondent for Time magazine and continues to write for other publications, many of which you all know well, the New York Times, The Guardian, the London Review of Books, The New Yorker. Her latest book, which is called Guest House for Young Widows, is based on years of immersive reporting and focuses on the women who have joined and escaped life in the Islamic State. In her current work, Azadeh has also visited and published on Nigeria and Somalia, some of the most difficult contexts for many of these issues, reflecting on women's roles in Boko Haram and Al-Shabaab, as well as the challenges they face upon return from these groups into their communities. Azadeh, it's a real pleasure to have you with us today. So as I've said, you've conducted this extensive fieldwork in the Middle East, in Nigeria and Somalia, and you've talked to many women who were forced to join, marry, and live their lives within terrorist groups. When they escape and they return to their societies of origin, as many of us know, they're often stigmatized, they're rejected, and they lack basic protection under law. And yet many of these women have been victims themselves. We're going to ask you to tell us a bit about your interviews. Did these women have an expectation of justice, and what are their expectations?
Thank you so much, Fionnuala. It's really wonderful to be here with all of you, and thank you to the organizers for this fantastic and timely event. So I'm going to very much frame my remarks in the context of relaying to you what I heard from the dozens of women that I've spoken to across several different contexts, fragile, conflict-affected contexts, Nigeria, Somalia, Northeast Syria, Southern Turkey, women who had affiliated or were formerly affiliated with ISIS. So it will very much be me relaying these conversations to you. I think it's important for us to hear from survivors what they want, what their priorities are, and the realities that they're contending with. So I'm going to frame my remarks that way and to sort of set out at the outset that most of them across all these contexts that I'll go to in more detail really simply wanted the sexual violence to stop because it was ongoing in many of the displaced and seemingly post-conflict contexts that they found themselves in. They badly wanted and needed support with the consequences they were experiencing from either, their first instance of traumatization or the ongoing sexual abuse and violence that they endured in their conflict settings. And very often, I think overall, their understandings of justice were quite different from those that we think about in the West. They were not punitive or carceral. They didn't associate justice with formal prosecution or punishment, but had other quite urgent needs in their context. So in Nigeria, I reviewed, dozens of interviews ahead of this conversation with women who had a whole different history of affiliations with Boko Haram and other groups, associated groups. Some had been kidnapped and then ended up marrying into the group and deciding to stay there. Some had joined willingly, but endured a lot of abuse and sought to leave. And I was really struck by how across all of these interviews that I went back and looked at, no one really mentioned prosecution. It just seemed to fall outside of the realm of what so many of these women imagined was possible. They were also so caught up in the material realities and the hardships of displacement, just the daily politics of survival in these displacement camps where sexual abuse was rampant and hunger was endemic. Remember a young woman called Aisha, who was 20, who had been kidnapped by Boko Haram, married into the group, had been caught by the military. And I spoke to her in a displacement camp. She said, "There's not enough food here. I'm not glad that I was rescued. I was more comfortable in the forest. Here in the camp, I'm insulted. It takes me a whole month to sew a cap that I barely get a few hundred naira for." Like others, she wanted to go back. There were other women who said to me, to live in these camps, to survive, to get enough food, you have to become a harlot. And they wanted to go back to Boko Haram. Some women who were captured who had been captured by Boko Haram and forced to marry into the group had members of Boko Haram kill their children that they had taken with them. There was a woman that I met who was 37. She had 3 kids when Boko Haram kidnapped her. All 3 of them were killed by Boko Haram. And the sexual abuse in the forced marriage that she endured, alongside the killing of her children, it was hard to see what she thought was the most urgent or the most sort of violation demanding of justice. So I think many of the women's priorities were simply an end to the sexual abuse and violence they were experiencing in those IDP camps. The acute deprivation of their circumstances made a whole sort of spectrum of different types of sexual exploitation and abuse quite rampant. The process of return, where they were screened by the military, the transition out of Boko Haram was a period of time rife with abuse. And so really they wanted protection from that, the ongoing abuse that they experienced outside of Boko Haram as well. That was their urgent priority, and greater support for what they experienced alongside that. Shelters for victims of rape in the camps, better access to health and medical care for those who had experienced violations, help dealing with the impact on their livelihoods, the stigma of people knowing that they had been assaulted. So in this context, and I know that Rhoda and Chioma will certainly talk more about this, I think justice efforts that were survivor focused were things that they mentioned a great deal. Shelters, improved healthcare, anti-stigma campaigns, and prevention through really, persuading people in their community that sexual violence was a profound crime, that it wasn't something you could punish by having, a young man sweep the camp, that it was a shame and a terrible suffering for women that should be taken more seriously. And to have that conveyed to communities in a way that would prevent it over time. In Somalia and Kenya, talking to women in the context of al-Shabaab, we spoke to women who had been married into al-Shabaab. Some of them had been coerced or pressured by their families into the group. One thing that really stood out was their insistence or their experience of what al-Shabaab had offered them. Many of them were very motivated to affiliate with al-Shabaab as they try to navigate the realities of a country where they're widely exposed to sexual violence anyway. Some of them felt like in some instances the group offered them some degree of physical safety. Many of them affiliated or associated with al-Shabaab because of access to justice. Of course, we know that they offer courts where women, where they uphold some degree of Islamic law, women who need to sue or petition for divorce or alimony in some instances. We heard that they were able to take rape cases to al-Shabaab courts. They were able to rely on those justice mechanisms. They didn't go to al-Shabaab necessarily because they wanted to, but because the state wasn't providing an alternative. So for women in this context who were exposed to an alternative system where they had access to some formal justice, they certainly wanted that. I think justice, victim and survivor focused efforts in these contexts would specifically be important around recognizing that state systems are weak, that women need legal aid and support through case management if they want to go through the formal system. And this has to start somewhere. There's really not a lot of effort spent, I think, building that nascent, very weak formal justice system up from the ground up. And I think that's important. And of course, and I think Anne-Marie might talk about this, the Somali parliament can finally pass the Sexual Offences Act, which criminalizes a wide range of sexual offenses. It needs to have a gender strategy of sorts, if al-Shabaab has a gender strategy of sorts. And finally, I will end with talking about women who affiliated with ISIS. I spoke to them in a number of different contexts, women who were Iraqi and Syrian or foreign from the 52 countries where women joined ISIS, living in detention camps in the northeast of Syria or in detention centers in Iraq, in the Syrian diaspora in Turkey, if they had managed to defect. Some were groomed as teenagers and married into the group. Some joined willingly, but were forced to remarry over and over again when their husbands died or were imprisoned or abused. In all of these contexts that I just mentioned, though, women were very much desperately keen. Their understanding of justice was that they needed aid in simply having some legal status where they could have some rights. Over 13,000 of them are stuck in these detention camps in northeast Syria, which is probably the bleakest place on earth. And they would say to me, why? I don't even have the rights of a prisoner. They won't try me. I don't have a trial. There are children dying in that camp, by the dozens, stripped of their nationalities if they've come from Western countries, beyond trying to, imagine a realm in which, the ISIS fighters who did horrible things to them could be prosecuted. They simply want the lowest common denominator of rights provision from the states that they were ostensibly citizens from. In Iraq, there's a subgroup of women amongst the sort of many hundreds of thousands of Iraqis who are still displaced, who are treated as guilty because they had relatives in ISIS. And especially women are living in contexts where they're still vulnerable to ongoing sexual abuse in IDP camps. They want and desperately need some legal autonomy because the state won't issue them with security clearances and ID cards, so they cannot register their children, they can't get them into school, they cannot get jobs, And these are steps that would also reduce their vulnerability and protect them, help them protect themselves from ongoing sexual exploitation and abuse. So in these contexts, I think what I heard most often was that women wanted to be treated like the regular criminals or those guilty of the political violence in their societies, rather than held in some suspended third Black dimension where they were eligible for no rights. They suddenly had no legal autonomy whatsoever. So to de-exceptionalize them really, and to get them out of this Black zone, to repatriate and prosecute and rehabilitate if that's appropriate, to have some access to medical care in these camps. And in Iraq itself, you know, I think one thing women said most of all is they need houses, they need reconstruction, they need the physical infrastructure of a life back. That in itself would be a great deal of protection. So to sum it all up, I think from my experience, all of these conversations really helped me recalibrate my own sense of what justice means to survivors of sexual abuse and exploitation in these terrorism contexts, because the context is far wider than the women's interaction with the group. I think we really must engage with the often desperate realities they are still facing and look at the ways that violence can be prevented in these contexts. How can real deterrence be brought about? How can women be supported dealing with the ongoing violence that they experience? And I think I shall stop there.
Great, thank you, Azadeh, for that very thought-provoking and complex analysis of both complex victimhood and complex situations that work against our presumptions, I think, and that's a really important way to frame our discussion today. I am going to move to introduce our second panelist, Anne-Marie de Brauer, who's a co-founder and team member of Impact, an expertise center whose mission is to contribute to prevent and address human trafficking and conflict-related sexual violence. From 2008 to 2016, Anne-Marie was also an associate professor in criminal and international criminal law at the University of Tilburg, and until 2019, she was a research fellow with the International Victimology Institute at Tilburg. She's published extensively on the investigation and prosecution of sexual violence, and most recently, Anne-Marie co-authored a piece addressing the nexus between terrorism, conflict-related sexual violence, and trafficking in human beings before national legal mechanisms. So I'm going to turn to Anne-Marie and ask her, in this article that you've published, Anne-Marie, you reflect on the nexus between conflict-related sexual violence and terrorism, and you look specifically at the cases of Nigeria and Somalia. You note that the existing legal frameworks fall short in acknowledging and criminalizing sexual violence, which has been committed by terrorist groups. Do you, maybe you could start by reflecting for us on whether you think it's important for the law to acknowledge the nexus between sexual violence and terrorism. And is it fair to say, in your view, that the current legal framework preempts the prosecution of sexual violence? And perhaps think also about the obstacles to prosecution. So let's turn over to your views on this important space of prosecution.
Thank you so much for the introduction, Fionnuala. And also thank you so much to the organizers for having me here today. And indeed, in the article that I co-authored with Eefje de Volder and also Christoph Paulussen for the special issue on conflict-related sexual violence for the Journal of International Criminal Justice, we really looked at why we think it's also important for the law to acknowledge the nexus between terrorism, human trafficking, and conflict-related sexual violence. And we abbreviated it to sexual terrorism. And as we also just heard from Azadeh, the law and the legal justice system is one thing, but of course justice for survivors of these crimes is much broader, and we shouldn't also forget that. But for the journal and for the article, we really looked at the law and at the nexus between those crimes. So what we did is, indeed, we looked at the laws currently available in Nigeria and Somalia to potentially address sexual terrorism committed by Boko Haram and Al-Shabaab. We looked, for instance, at domestic penal codes on rape, but also other forms of sexual violence. We looked at domestic laws on human trafficking, and we also looked whether the ICC implementing legislation on genocide and war crimes and crimes against humanity was implemented. We also looked at specific terrorism legislation, and in the case of Nigeria's Terrorism Act, we found that sexual terrorism could indeed be classified under existing acts of terrorism. For example, under an attack against a person's life, which may cause serious bodily harm, or an act that seriously intimidates a population. So these acts could include forms of sexual violence, we felt. So on the other hand, when we looked at the laws in Somalia, Somalia does not have any specific terrorism legislation. And as was just mentioned already, until very recently, Somalia did have quite a progressive sexual offences bill aimed at criminalizing a wide range of sexual and gender-based violence crimes, including rape, child marriage, and also trafficking for sexual exploitation, and also good supportive and protective measures. It had been pending before the lower house of parliament for over 2 years until this August, when actually a new bill, the Sexual Intercourse Bill, was suddenly introduced before legislators. This new bill will allows for girls who reach puberty to be married. And it needs to be seen what will happen next, actually. Well, what we found out that although there are several domestic laws that could potentially address sexual terrorism, none are really fully equipped to do so. For instance, due to outdated rape provisions, such as a rape within marriage, which is not held to be a crime. Or these laws were not even implemented or used to prosecute the crime of sexual terrorism. And this means that to date, there are no convictions for sexual terrorism as such. So in the absence of a law criminalizing the crime of sexual terrorism explicitly or even implicitly, access to justice by victims is severely curtailed. And in addition, we felt that recognizing the nexus between terrorism, human trafficking, and conflict-related sexual violence would also lead to actually more awareness about how terrorist groups operate. And also how much overlap there is between all these different fields of law, and thus the many different ways these terrorist groups could be prosecuted. And that's why we think that it's important to have recognition of sexual terrorism as a crime in itself, as it will better ensure that this crime is not fully under-investigated and instead appropriately prosecuted. Because we believe that only full accountability for the actual crimes committed will do some justice to the survivors. And not prosecuting these crimes under vague charges such as a membership of or affiliation with a terrorist organization. Survivors are entitled to have the crimes committed against them recognized. And at the same time, we also understand that legislatures must ensure that any expansion of the terrorism definitions are in line with, for instance, the model definition as suggested by Martin Scheinin, including compliance with international law, because this will help to ensure that the terrorism label is not broadened too much and applied to all kinds and forms of criminality. Yet, we also understand that it may be very difficult, politically or otherwise, to amend existing terrorism legislation, if available, to include sexual terrorism as a crime in its own right. As presently, prosecutions for sexual terrorism are practically nihil, it may be just as important to focus on already existing opportunities. I already mentioned the possibilities in the Terrorism Act in Nigeria. But of course, also other domestic laws could be amended so that the sexual terrorism could be prosecuted under those laws. After all, one has to start somewhere. And it's more important that these crimes are prosecuted in the end than discussing at length under which crime or definition this should be. And another question we felt is how survivors of these crimes look upon this themselves. So this may be, is the label of the crime important? And if so, what label would they prefer? This may be very depending on the particular victim or the victims or even the situation at hand, and could, for instance, be, it could be a recognition of sexual violence as a form of genocide or a form of terrorism or even otherwise. I'm very curious also how the other panelists are looking at this and the audience. And while writing actually the article for the special issue, we were also searching ourselves for the best possible solution. And we wanted to move the discussion on this issue forward. So looking at the second part actually of the question, so beyond the legal framework, what other obstacles explain actually the absence of prosecutions for these crimes? We identified several. So for instance, the first obstacle that we identified is that apart from a lack of a clear prohibition of sexual terrorism, as I just talked about, there's also a need actually for a survivor-centric approach, for survivor-centric procedural and evidentiary rules to support and protect victims in the proceedings. And this is oftentimes lacking. For instance, one can think of rules that require corroboration of the claim made by the victim. So if medical reports or more witnesses are needed to support the claim of sexual terrorism by the victim, this can be very detrimental to the victim's case, at least most of the times. Another obstacle that we felt was the lack of understanding about sexual terrorism by government officials, and at times even their possible complicity in this, as well as insufficient resources. So investigating and prosecuting authorities are often unaware of the elements of the different crimes, so conflict-related sexual violence, human trafficking and terrorism, and how these can actually be identified, let alone as a standalone crime of sexual terrorism. So we feel that a better understanding of sexual terrorism as a crime may even be needed by the audience at large, including survivors, and that they know also what their rights are in terms of the proceedings. Another obstacle we felt was the general lack of confidence by victims in state institutions, including the criminal justice system and the police. For example, in Somalia, we found that women, out of fear of abuse, but also humiliation, because they can be accused of lying or victim blaming, they fail to report their cases to the police. Another obstacle we identified is the occurrence of sexual and gender-based violence as more or less a normality in everyday life. And this really constrains women's autonomy and opportunities, including not seeking help or going to court. For instance, in Somalia, we found there is a general impunity with regard to sexual and gender-based crimes, so not even linked to terrorism or a conflict situation. And women who do complain about rape face the risk to be accused themselves sometimes of adultery or insults. So also the cultural and societal acceptance of acts of sexual violence makes it all the harder to ensure that sexual terrorism inflicted by Al-Shabaab does not remain unpunished. A final obstacle that explains the absence of prosecutions of sexual terrorism is the fear of reporting sexual terrorism due to security concerns and family, community, and societal stigma. So for instance, in the case of Somalia, some women fear to come forward, or as they risk being mistakenly identified as an Al-Shabaab sympathizer. So I will leave it at this for the moment. Great. I'm really looking forward to hear more.
Thank you, Anne-Marie, and we appreciate the sort of detailed analysis, particularly at the technical and national level, of the challenges of prosecuting and charging sexual and gender-based violence. So it gives us really a great way to move to our next speaker, and our next panelist is Chioma Onegbu, who is the Deputy Director in the Department of Public Prosecution of the Federation, and is the Head of Complex Cases, a specialized prosecution unit within the Office of the Attorney General. The CCG indicts and prosecutes alleged Boko Haram members based on evidence collected and submitted by the Joint Investigation Commission. And this is an interagency body composed of investigators from different state agencies, the police, the intelligence, and the military. So a really complex national context to be working in. And so my question, Chioma, is since 2017, as you know very well, Nigeria has tried thousands of alleged Boko Haram fighters. And the complex case group that you currently lead is the unit within the Attorney General's office that's responsible for these prosecutions. So while Boko Haram is known for kidnapping, for rape and forced marriages of women, as yet no fighters have been prosecuted for these crimes. I wonder if you could tell us, in your opinion, what are the obstacles to ensuring such crimes are brought to justice, and how at the national level we can address these crimes. So I'm going to turn over to you.
Thank you very much. You know that the Nigerian legal system, that is the Terrorism Prevention Act 2011 as amended, did not criminalize sexual violence, gender-based violence. But with the capacity building of Wayamo, I remember in 2019, to be precise, June, where Sophia present here came and asked us to look at the elements of the crime. So on that basis, we started looking at the elements of crime once they brought the case file, that is the JIC. And from the elements of the crime, we were able to look at the Section 1, Subsection 2I of Terrorism Prevention Act 2011 as amended, which talks about an attack upon a person's life which may cause serious bodily harm. On that basis, we have been able to prepare some charges awaiting trial. Recently, we got a file investigated by the DSS, which talks about the defendant made a confessional statement that he married a Chibok girl. So on that, the investigators stopped at that. They couldn't investigate further to check whether actually the name given by the defendant is a Chibok girl. But when the file came to us, we have to write to the Federal Ministry of Women Affairs to confirm actually whether the name given by the suspect in the file is correct. And they confirmed actually that the name is a Chibok girl. On that basis, we were able to file charges on Section 1, Subsection 2, that is infliction of bodily harm and equally kidnapping. So we have had a lot of challenges in prosecution of this session due to fear of stigma associated with SGBV, inadequate women in the key positions in national agencies, inadequate gender-sensitive trainings, inadequate medio-legal evidence, and equally inadequate information sharing of evidence. So my recommendation in this, the way forward is for us to develop and maintain information storage sharing, recording and digitalization of system, continue to develop and expert prosecutors by continuous trainings, capacity building, creation of specialized units to deal with the gender-related cases, enhancing cooperation and coordination between relevant criminal justice actors, develop a strategic to lobby the National Assembly, because presently we have a 2019 bill that wants to repeal this 2013 Act. So if it can be amended and include in the TPA SGBV crimes, it will be a way forward. We equally have to have a good case management in the system, ensure that prosecutors who are trained in dealing with the gender-based sensitive issues are deployed to work with the investigators. Thank you very much.
Thank you very much, Chioma. And I think it's really helpful for us to see the challenging work that's being done at a national level, the complexity of dealing with these cases, and the concrete ways that we can move forward to do that. So that's a really, I think, important insight for us at the global level to really be attuned to what's happening at the national level. Our next panelist is Rhoda Prevail-Tiden. Rhoda is the president of the International Women's Lawyers in Nigeria, FIDA. FIDA is an NGO focused on the protection and promotion of the rights of women and children in Nigeria. Nigeria's we have the organization is present in 34 states of the Federation, including in the states that are most affected by the activities of Boko Haram. So I'm really pleased to have Rhoda speak to us. And so I wondered, given, Rhoda, that FIDA is present in many IDP camps in the Northeast, and it's providing assistance to women who escaped Boko Haram, I wonder if you could talk to us about the challenges that are faced by these women in the particular, and whether access to justice is or can be a priority for them. Based on your own experience, what do you think can be done to ensure that access to justice becomes important for these women and for their communities? So Rhoda, over to you.
Thank you, Finola, and good evening to the panelists. I'm happy to be here, and I thank you for the platform created for FIDA to say what we do. Access to justice, as we all know, is an essential instrument for human rights and for rule of law to flourish in any nation, including Nigeria. And access to justice encompasses that recognition is given to everyone who is entitled to protection of law. Talking about the women in the IDP camps where we work, they are all returnees from former strongholds of Boko Haram and would have suffered one form of sexual violence or the other. Whether justice, access to justice is a priority to them. For me, and for us in FIDA, the need for justice for these women cannot be overemphasized, because it is impossible for them to enjoy and realize their rights, which are natural and essential for their development, because they have a right to enjoy a proper and harmonious development of their personalities without any form of discrimination. But unfortunately, most of these women in the camp whom we relate with do not even know that they have these rights, because most of them are uneducated and they are indigent, and they are not aware, I can say, of the ongoing trials of the Boko Haram terrorists. And they are supposed to be a part of this, because like Chioma has said, unfortunately, the Terrorism and Prohibition Act of 2013 does not recognize sexual violence as an activity of terrorism. So these women are not even aware that these trials are ongoing. And I can tell you that these women do not have any confidence in the judicial system, because to them, justice to them now is having to survive. What they want is survival, and survival has not been easy. Every day they are struggling for survival. They are battling to get out of the scarce resources and the inadequate humanitarian assistance that is available to them, which is one of the things that makes them so vulnerable. So with what is happening to them in the camp, they are sexually violated, they are harassed, they have to fight for everything. It is sex for food, it is sex for security. So because of the condition they find themselves in these IDP camps, they are reluctant to report the perpetrators of this violence and abuse for the fear of reprisal attack, and also stigmatization and attack on their families and communities. Don't forget, these women are also trying to see how they can be reintegrated into the society. So they should be encouraged, to me, and for us in FIDA, we believe they should be encouraged to participate in the criminal justice system process. For this will give them a voice which will help with the healing process. And then they should be provided with resources. While we work with them in the camps, their fear mostly is stigmatization, fear of reprisal attack, fear of victimization in the camp, refusal to give them food if they go to report these cases. So they are reluctant to even report the perpetrators of this sexual violence, even in the camp. So it is important to note that while they would like to access justice, but that may not be their priority. Their priority is to survive. Their priority is to be reintegrated into their communities and into their families. Some of them have been reintegrated, but some of them are treated with distrust, especially for those of them that came back with children. These children are attacked, bad blood, and they are ostracized. So these women go through a lot of all these kind of harassments. So talking about access to justice for them may not be it, but we believe that these women should be encouraged to access justice. What are the measures that can facilitate access to justice? I think the societal viewpoint about these women must be changed, their education, orientation, sensitization, so that it will reduce the stigma associated with having been with Boko Haram. Proactive measures need to be taken to improve Nigeria's response to cases of sexual violence and offenses, and a commitment on the part of government to combat it by improving service delivery and enhance protections in the camp. Government must, as a policy, be deliberate in its effort to ensure that there are mechanisms that are put in place to ensure for access to justice, devoid of all the bottlenecks in the justice system. We know it is not easy to get justice in Nigeria. We have delays, we have the high cost of it. So we need to have legislative framework which should be strengthened. Choma has said it. We have international convention protocols that Nigeria has ratified, but they are yet to be domesticated. And the existing laws need to be reviewed. And then gender neutral laws need to be enacted. And what do we have on CAM? We have Legal Aid Council, but how far have they gone with that? So we advise that government and international organizations should try to see that they enhance the legal aid institutions for an effective and more efficient service delivery. And gender-based violence services like psychosocial and legal social support should be provided for victims on this scam. There is no domestic legislation that criminalizes sexual violence, like Choma has said, in times of conflict, despite the fact of ratifying some of these protocols, international conventions. CEDAW is one, but that has not been domesticated by Nigeria. No wonder then, up to date, we have not seen any single member of Boko Haram terrorists prosecuted for sexual violence, despite the fact that it is being used as a weapon of war. The terrorism prevention, I'm happy to hear her say that it is being proposed for amendment. It should be amended because sexual violence and other forms of conflict-related gender-based violence should be treated as terrorist activities. So this law needs to be amended. And then government also to strengthen the credibility and capacity of security agencies that are charged with protecting these women in the camps. Systems should be put in place to ensure that there is proper oversight and accountability to prevent all these things that we hear about, women being sexually harassed and nobody has ever been prosecuted for doing that. These women need to be safeguarded from repeat victimization, even in court processes. We go to court for them on some domestic cases and all that, but they need to be protected. Their rights have to be safeguarded. What they want is protection. They want to be treated with respect from intimidation and abuse. Civil society organizations, non-governmental organizations are all over in most of these camps. So I think that the government and the international community should strengthen these CSOs and NGOs as the foundation for promoting access to justice, because they do a lot. Even if we don't have the law, we have a constitution which provides for protection of individuals. And I think even in the absence of a non-law, we can come under the constitution to prosecute this act of sexual violence within the terrorism context, because Section 34 of the Constitution is clear. Everybody is entitled to respect for dignity. So we can come under that. We have the Violence Against Persons Prohibition Act, which has been passed. It's a national legislation operational in Abuja, but Adamawa, Borno, Yobe are yet to domesticate that. And in that act, it has a crime compensation requirement, which will help the victims to a large extent for rehabilitation. So government can help with resources to empower these women. That way, they will be more prepared and willing to want to access justice. So what FIDA is doing is trying to sensitize them. We have trained paralegals amongst them, and we try to sensitize them on the fact that they have rights and they can push for redress when their rights are violated. But most importantly, a lot needs to be done by government to ensure that these women are confident in the system to come forth and claim for a redress of their rights when they are violated. Thank you very much.
Thank you very much, Rhoda. I'm really struck by both the work that you're doing in the camps, providing this assistance to women and girls, but also just how vividly the double squeeze for victims is so obvious, both from the armed groups that they are escaping from, but also then the subsequent layering of sexual and other harms that they're experiencing, either by the state or by private actors in situations that ought to be safe. And so this brings me back, I think, to sort of tie the end and the beginning of our discussion, where Azide's opening really had us think about some of these very complex intersections that we see in this space. So Azadeh, I wonder if, based on your own research and as you've listened to the conversation today, if you could reflect on whether you think the prosecution of members of terrorist groups such as Boko Haram will be helpful to victims and change the dynamics of reintegration, or what else is needed in addition to that.
Thank you. What a brilliant presentation from Rhoda and from the others. I really appreciate Rhoda's dwelling on justice, despite recognizing also the other urgent survival realities for women in the camps. I think justice can't be pushed to the side because there are more urgent needs and priorities that women might have. And I think we do have to remember, so many of them would talk about what drew them to Boko Haram in the first place, if we're going back to, the early days. And there was a message of justice for women. And so I think there's got to be a message of justice in their reintegration and support for them. Again, I'm going to go back to what I heard a lot from communities in Northeast Nigeria when I was doing field research there. And of course, there's a crucial link between justice and reintegration dynamics to make this reintegration process more successful so that women don't end up going back. Something that we heard a lot that communities wanted, and when justice came up so often, two things were mentioned. And I guess we're pivoting a little bit. I'm pivoting to talk about communities who are being asked to accept perpetrator victims back, because so much of the dynamics of reintegration are in their hands. We heard that they want compensation. For them, compensation was justice. And watching returnees being given livelihood training, support in these camps, so often, we would hear, they're the ones who chose the path of violence. Like, my house was burned down, my cars were burned down, I lost my entire life, I've lost my farm. They're the ones who chose violence. I want to be compensated. I need to rebuild. I need you to compensate me for what I lost. And instead, these perpetrators are getting sewing kits and machines, and they're getting all this support. So sort of recentering the communities who were victimized, so their sense of justice, or what we think of as justice that they want, can be centered on what they're saying, which is, I think, very much, recompensation, any kind of compensation that can help them rebuild their lives. And I think that's complicated, and there's a whole separate conversation to be had about how best to do that. I think one of the smartest things we heard in the end was soft loans to households, because if it's just sort of one-off compensation, there's a danger of those who deserve it not getting enough, and it not being distributed in the right way. So tangible justice in the form of compensation for victims, straight up victims. And then in terms of other kinds of justice, we heard a lot about the need for reconciliation and forgiveness rather than prosecution. So often people would say, I just want to come back and say sorry for all of the people in my family who were killed. say sorry for what I did, forgive me. This is a process that I think could be very powerful. And if so many people, are saying that this is what they want, I think it's a worthy pathway to explore. Religious leaders could play a big role in this. I think many religious leaders are themselves deeply impacted by this violence. Perhaps they don't want to preach forgiveness. So to be supported in that process, to have a kind of coming together, based on the South African model or the Tunisian model, whatever it is, to have some sort of two-pronged process where there's compensation for those who lost all their livelihoods, so they feel that they're getting something tangible back, alongside a reconciliation process where they can come face to face or see, in some setting, that those who hurt them are seeking to come back into the fold and asking forgiveness. So that's really what we heard profoundly from so many people. And so I would say, alongside the need to strengthen all these procedures so that women who do want it can eventually have a pathway that doesn't re-traumatize them, that doesn't take 2 years of their life and threats to their families. I mean, that is absolutely worthy. But alongside that, because this insurgency is ongoing, because women who come back are suspected of still ferrying intelligence and food to insurgents, I think there's got to be like a very tangible program centered around what communities say they want, which is compensation, help rebuilding their lives, and a reconciliation process where they can be asked to forgive. I think people want to have that asked of them by those who they feel hurt them.
Great, thank you, Azadeh. And I think that's a really, the complexity, but also the nuance of this conversation, where we don't think in silos or linear ways, seems to me, particularly in the context of the mandate I hold, particularly important in addressing this terrain. So it's been a real privilege for me. These are a remarkable group of women doing really difficult and challenging work, many at the cold face of the harms and the challenges, both in terms of the legal, social, and political dimensions of this. So we're going to turn from this sort of presentational mode to take some more questions. We've had a couple of questions that were put to us through the audience, and so I'm going to take the opportunity to try to turn those questions back to our speakers. And I'm going to start with Anne-Marie, if that's okay. Anne-Marie, I wondered if you could reflect on the following. Policy responses and legal frameworks applied to terrorism are often gender blind, and they can lead to misconceptions about what kinds of harms have been suffered and what victims need. So how do you think we can best ensure that the plight of victims of sexual violence is reflected in legal responses, particularly given that challenge of sort of the presumption of gender blindness in the space? And if you would take just 3 to 4 minutes to answer the question, that would be great, so we get through all of the questions of the audience.
Yes, thank you. I think it's important that the court, and it has been said already a few times, that the court implements survivor-centric evidentiary and procedural rules. Effective prohibitions, I think, against sexual terrorism are insufficient without amendments to procedural and evidentiary rules that do not really support or protect victims. So the rules of procedure and evidence, I think, should be guided by a survivor-centric approach. And such an approach will help to protect the victims or survivors' dignity, their health, their life, including from secondary traumatization. So, for instance, there is really a strong need for protective measures. Victims who testify or participate in court should not risk their lives or receive threats because of it. So, for instance, imposing confidentiality measures by the court could be a possibility. Using in-camera proceedings could be an option, but also the availability of trauma and support persons before, during, and after the court process is, of course, important. And there's also a need for measures to protect victims from secondary victimization. For example, the rules that protect victims from intimidating questions by the accused that do not really serve a real evidentiary purpose, except maybe intimidating the victim. And the court could, for instance, establish internal protocols that actually foresee in the obligations of judges intervening when these kind of questions are posed to the victims. Or rules that prohibit to question the victim on a previous sexual past, are also rules that state that corroboration in cases of sexual terrorism is not actually necessary. And I believe that guidance for the implementation of these kind of survivor-centric rules can be really found in international rules that have already been developed, such as we can think of the rules of procedure and evidence at the International Criminal Court, but also the International Protocol on the documentation and prosecution of sexual violence in conflict, and the soon to be finalized Murad Code. And there are other sources like this, including on the protection and support for male victims and also children who are victims of human trafficking and conflict-related sexual violence. And then, of course, reparation and assistance via the court or even outside the court should be provided to the victims. And this has already been said before. And I think the input from the survivors themselves on all these issues is very much needed. So on the obstacles they face in access to justice and what they wish to be remedied. And even now, 20 years since the adoption of UN Resolution 1325 on women, peace and security, I think the women, peace and security agenda itself also states clearly that women meaningfully have to participate in important decisions related to peace and security. So this would include women and girls, including survivors of sexual terrorism, to have their say on what justice actually means to them and how it should be organized.
Great, thanks for that reflection. I'm going to turn to Rhoda, and the question I'm going to ask you, Rhoda, is both one that it's come in before our session, but also is reflected in the Q&A comment box by one of our many listeners online today. So Rhoda, if you could tell us, if you think about, as you know, your own context in Nigeria, victims of terrorism, and in this case, the victims of Boko Haram, as you have so articulately articulated for us, many of them are now in camps run by NGOs or humanitarian organizations. I wonder if you could address the challenge of addressing the obligations of those humanitarians in these camps when sexual violence is experienced in the camps. How can those organizations meaningfully reverse the trends and address sexual harms that are committed often by their own staff or by those who are in theory there to help? Rhoda, I think we can't hear you, so maybe if you can, yeah, perfect.
Thank you.
Thank
Can you hear me now? Yes, thank you very much for that question. FIDA is one of those organizations working in the IDP camps. And like I said, what we are doing there in collaboration with other NGOs is to help sensitize these victims and these women on the need to speak out against sexual violence in the camp. But the fear of reprisal attack is what keeps them from doing it. The NGOs and the CSOs that are working in these camps that are supposed to help these victims with information on how to access justice, on how to access some of these humanitarian assistance that are given, are the same people that turn around to victimize these women. So these women need a lot of sensitization and awareness education to speak out, because the silence is what has exacerbated the committance of this offense, because they are not speaking out, they are not reporting, and like I said, they have lost confidence in the system. They believe that even if they report it, nothing can be done. So why do we report it? So what we need to do is for government to take up proactive measures to improve the government response to these incidences. And to do that, we need gender-based violence structures on ground. Like, unfortunately, Nigeria, these states, the 3 states, have not adopted the Violence Against Persons Prohibition Act, because most states that have adopted, they have what we call the sexual assault referral centers. If they had adopted this, and if this could be done on this camp, I believe that it will help a lot, because right there, these victims will not have to go through the humiliation they may likely go through in police stations, in courts, when they have to appear in courts. These referral centers are a one-stop shop where you have the lawyer, you have the police, you have the psychosocial therapists, you have the trauma therapists that will assist them. And that way, they will be encouraged to speak out. And that way, they will also be encouraged to push for redress of their rights, which has been violated. But I think government needs to be more sensitive to what is happening in these camps. These perpetrators must be brought to book. These perpetrators must be punished, so that these women will now build up confidence in the system. They know that when something like that happens and it is reported, action is taken, whether it is by an NGO staff or it is police or whatever security government official. Action should be taken to punish such perpetrators. Until we do that, I don't think they will be able to come out of that out of silence to speak. So we need to do much more by sensitizing them on the need to speak out, and then government to take up proactive measures to ensure that they are assured of their safety and protection. Okay.
Maybe this would be a good time to bring in Chioma on the same question, but maybe just a little bit more specific, Chioma, particularly in the context of complex humanitarian settings such as camps. Could you talk a little bit about the challenges for prosecutors in having access to victims in the camps? The challenges or the positives, any good examples that you've seen in your own work of cooperation between prosecutors and NGOs, and just how to manage as a prosecutor the complexity of building a case in conditions that are often extremely challenging, and where access and even the capacity to engage is restricted for you as a prosecutor. If you could speak to that.
Thank you. As a prosecutor, we depend solely on investigation, on evidence, but we don't have evidence. The investigation we normally get is confessional-based investigation. It is high time our investigators move away from the confessional-based investigation to evidence-based investigation. They conclude investigation based on the confession of the suspects. They don't move away from that to investigate actually what has been confessed is true or false. Like I earlier gave you an evidence of where the defendant confessed that he married a Chibok girl. They couldn't move away to check actually whether the confession is even true. Is it actually the name given? Is the name given actually from Chibok? They didn't do so. So if it's in terms of the civil societies, the UNODC have been trying in conducting workshops where they gather MBAs, civil societies through workshops. So there is a good cooperation among the NGOs. But the problem is the victims. We don't have access to the victims. So that has to be changed to enable us get a good evidence. Thank you.
Thank you, Chioma. I think that raises some really complex questions, which we've dealt with in other contexts, about access to evidence in conflict sites. It makes it, I think those of us who've worked as prosecutors know how difficult it is to construct evidence in the context of ongoing hostilities, and the expectations, because the balance here are always around fair trial and how do you in fact ensure that you have sufficient evidence to bring someone to criminal conviction. Another issue I'd like to raise, perhaps maybe Chioma first and then perhaps to Anne-Marie, Chioma, would be, could you talk about where you think training makes a difference? Where does it help in the context of prosecuting sexual and gender-based violence? where can training help, whether it's training prosecutors, training judges, training humanitarians, those who are most directly working with individuals in the camp. Could you speak a little bit to that? And then I'm going to go to Anne-Marie and ask her to reflect from her writings on where she thinks training can be helpful. But let's start with Chioma again.
Yeah, training will be helpful, but who do you train? If you check an investigation conducted by a male officer and the one conducted by a female, the female understands themselves. There should be a gender-sensitive officers who can be trained to handle these SGBV cases. Also, we have to encourage forensic investigation rather than confessional-based investigation. If actually a defendant or a suspect confessed, they should move away from that and investigate and check whether the confessions are true or false. This can be done through workshops. Then there had to be a sensitization of the victim to avoid stigmatization because they are afraid of coming out to voice out. Actually see they have been sexually violated. I remember there was a time I went to Meduguri, to Giwa Barras, to investigate the females there to ensure that I see whether I can get evidence. But they all denied that there was no sexually violation among those with them. So from workshops and sensitization, we'll be able to achieve something. Thank you.
Thank you, Chioma. And maybe Anne-Marie, if you could just think about that question of where you think training can be helpful in the whether it's the sensitization or in the capacity to actually get cases through, because historically we also know that even in the ad hoc tribunals where there was a lot of training, the actual capacity to deliver outcomes was really limited. So we actually have a much this isn't just a problem in this arena, it's a much broader problem.
Yes, indeed. I think it's really important also to have these trainings and to train investigating and prosecuting authorities on successful prosecutions of sexual terrorism, and the investigation and prosecutions. The investigating and prosecuting authorities, we felt also, and as we wrote down also in our article, are sometimes also unaware of the elements of the different crimes, as we were also trying, of course, in the case of sexual terrorism, to see where the nexus is between terrorism, human trafficking, and conflict-related sexual violence. So unaware of all the elements of the different crimes and how these can also be identified, and let alone as a standalone crime of sexual terrorism. So the first step can also already be the awareness and identification towards the investigation and prosecution of sexual terrorism. So we believe that authorities can be trained to recognize the different forms of criminality and also their nexus, but also that authorities must understand that victims of these crimes are frequently also victims of other crimes, as has been said during this panel discussion several times. So like forced labor or torture. And in fact, also in our article, we elaborate on this matter and we look at where is the nexus actually between human trafficking and conflict-related sexual violence, because it oftentimes meets in the crime of enslavement. And this is because victims of sexual terrorism are frequently not only victims of sexual crimes, as has been said before, but they are also forced to work in the household or to fight or otherwise. So in addition to that, I think states must encourage also interdepartmental cooperation between counterterrorism specialists, officers fighting human trafficking, and also sexual violence experts or conflict-related sexual violence experts. And then finally, as has been mentioned several times, I think that the training should really go into how the court proceedings could be as survivor-centered as possible. And this would require this discussion on all the survivor-centric procedural and evidentiary rules to support and protect victims in the proceedings. And apart from all of this, we also need a long-term investment in societal changes about gender norms. As I mentioned before, the introduction of the new bill in Somalia shows that introducing norms and values should equally meet these type of interactions. Otherwise, the norms may not be internalized and even be counterproductive measures can be taken. So the law and training of judicial actors is one step, but acceptance of the norms as unacceptable also need to come from society within, or else there will also be no cases in the end and all efforts will be in vain. So as has been said before, you can engage with religious and traditional leaders in this quest. And this will be a long-term strategy. Yes, sorry.
No, that's great. So in terms of long-term strategies so one of the things that's really, I think, come out from your work and also from your remarks today is that in many of these contexts that we're talking about, the actual geographies, the specific places that we are talking about, human rights violations are massive. There's scalar human rights violations, and they are so vast and so overwhelming that national criminal justice systems are just overwhelmed. And often they're weak to start with. They didn't start off being robust systems, which is often part of the causality of the violence. So that makes it really difficult to provide redress to victims. So you've talked a little bit about the importance of other mechanisms, but I wonder if you'd reflect briefly on why in that context of scarcity, right, scarce resources to justice, why other mechanisms are important and perhaps more compelling or have to be thought of and used in ways to compensate for the limited capacities we have in criminal justice systems.
Thank you. I mean, I think indeed the sort of scope of the challenge that many of these societies are up against, Anne-Marie and Chioma, just, at the level of the sheer institutional and societal need for sensitization alone is so daunting. One thing that I think can be impactful and indeed, there are so many places, Morocco, Tunisia, where, at Crisis Group, we've been even reluctant or cautious in urging repatriation to some of those systems because of concerns about the rights compliance within them. Something that can be sort of adjacent to this kind of prosecution is, again, I will return to transitional justice, because I think perhaps it's almost kind of fallen out of favor. It's sort of not even stylish to discuss it anymore. But in Tunisia, which is a country where actually there was a quite extraordinary Truth and Dignity Commission to sort of account for and societally process many of the crimes that people endured under the dictatorship of Ben Ali. I sat in on some of those hearings and these are historic crimes. So, the profound social impact that it had even 20 years later. I mean, I remember a hearing where there was a 47-year-old woman who was talking about things that had happened to her in her 20s, and it was broadcast on national television on prime time. The whole country was transfixed, and it was amazing. I mean, I've worked for 20 years in Iraq, Iran, and so many places where there's been, endemic, ongoing, sexual violence and so much impunity. This is perhaps the single most powerful experience I've had in sort of seeing on a national level victims come forward in a hearing where, they're assembled. And the way that it was organized, the woman who talked about her abuse by security forces, being all her clothes taken off, being threatened with sodomy, so many things happened to her, saying all this on television. It was alongside others who were testifying about other things. So her experience of sexual violence came alongside financial corruption and torture. And so it was sort of part of a mosaic of harms that many had endured. It wasn't sort of set apart. I think that buffered the kind of the sort of societal aversion in conservative societies to dealing with just straight on, cases of sexual violence on their own. And I think it was profound. I mean, perpetrators were separate. It was a hearing just for survivors. But I think it was tremendous. When I would speak to young women who had been caught up in the recruitment of ISIS, had been rounded up by police, they were not subject to some of the same things. And I think that somehow these hearings had trickled down, you know, these older women who were more mature, they were more confident, they had spent years as activists in and out of prison, and they were ready on the far other side of that experience to come forward and talk about it, had this oversized impact. And I think these kinds of efforts broadcast on television, where one or two powerful figures, senior women who've been through this, you know, can have so much impact.
Yeah, and I think that's really helpful as a day and reflects two questions in the question and answer scroll that those seeing from Mariana Botero and Bibi van Ginkel, the importance perhaps of thinking about transitional justice mechanisms in this space. It's certainly an issue that the mandate I hold grapples with every day in terms of what are the mechanisms that we can successfully apply. I'm going to go to Rhoda and ask her a question about the state. So in many of the contexts, and I think Nigeria is so much in our minds these days as we're watching the news from your country, that as we know, terrorism in many contexts arises in the context where the state has failed, or the state is fragile, and the conditions conducive mean that the population have very little trust in the state. So it's again this squeeze that we find victims in, caught between the non-state actor and the failures of the state. And so I wonder, in the context of that we're thinking about, Rhoda, in your own context, where do you think responding to and addressing the needs of victims of sexual violence can help restore trust, or can it help restore trust in the state in any way? Or does that place too much of a burden on prosecution? So I'd be interested to hear your thoughts on that.
Thank you very much. Choma has said the problems they encounter in the prosecuting these cases. And I want to say that on that, much still needs to be done by the government. The government has to come in with proactive measures that will give the victims the confidence that they can trust the government for their protection and for redressing these sexual violence offenses. What we see is the legislative framework is very weak. And until something is done about that, we'll continue to have problems with sexual violence cases going unreported and unprosecuted. And that is why states have to take it up. States have to make a deliberate effort to ensure that proactive measures are put in place to prosecute sexual gender-based violence. I can tell you that during the COVID-19, because of the spike in sexual violence cases, the Governors Forum, which is made up of all the governors of the 36 states, including the federal capital, declared a state of emergency on sexual gender-based violence. And we have seen that most of the states have gone back to take up measures to ensure that these cases are prosecuted, to ensure that they combat this, the occurrence of these cases. And what are some of the measures that the states took? They adopted gender-neutral laws, like the Violence Against Persons Prohibition Act that we talked about, has been adopted in, I think, about 15 states. And this is a benchmark legislation on sexual gender-based violence. And apart from adopting these laws, most of these states also came up with what I said earlier, sexual assault referral centers, to ensure that victims of sexual gender-based violence receive the necessary attention, are encouraged to speak out, are safeguarded from the likelihood of reprisal attack and the stigmatization. So in these centers, the victims walk in and they have all the people in place that will attend to them. So much for me still needs to be done by the states. While the CSOs and the NGOs are doing their own bit, the states have to also ensure that the legal framework is strengthened in such a way that whoever is taking up this case knows that this case is going somewhere, not when a case is reported to you and you don't know which law to use, or you get to court and you get stuck because in that state, they don't have any law that has criminalized sexual gender-based violence like we see. But I said earlier on, even our constitution makes provision for the protection of the integrity and dignity of persons. So we can still come under that. So the states have to ensure that the victims of sexual violence are assured of their safety and protection. Victims must be safeguarded from repeat victimization during court proceedings, because some of them, when you talk to them, they say they don't like it when they go to police station and they keep repeating, tell us about what happened, tell us about what happened. They repeat it over and over again. And the same thing also happens in court. So one of the measures that we think in FIDA Nigeria that such things could be addressed is for the courts, for the states to also come up with designated courts to try these cases, especially so that it is devoid of all the bureaucratic activism that goes in regular courts. So if states can come up with specialized courts, it will help because it will reduce the distress time that a victim goes through when such a case comes up. And it will encourage them to speak out because they know that justice will be dispensed within a very short time.
That's great, thank you. Much, I think, practical wisdom in all of that. And I think we've come to the end of the Q&A session, and it's my challenging task to make some closing remarks in these last couple of minutes. First, to thank all our really extraordinary speakers and for their wisdom and for the insights they've brought to us. I think to underscore the work of the UN team of experts here, prioritizing in particular the void of accountability for sexual violence and the need to address that void. The team is working in some of the hardest contexts around the globe: Iraq, Syria, Mali and Nigeria, which all of whom have long-standing historic deficits on the prosecution of sexual and gender-based violence. And so when we layer in complex conflict situations and acts of terrorism into those spaces, I think the scale of the challenge faced is not just a new one, it's a really old embedded challenge with new layers. I think there's a broad agreement across our panel and in the work that there is an absence of sufficient complexity in domestic legislation to address the crimes that have been committed. And it is the case, and I think these are certainly remarks I will make, that we do have existing bodies of laws. One of the challenges, they're not used enough to address these violences in ways both nationally and internationally. I think what I do want to say as Special Rapporteur, and to reflect maybe on how some of this work intersects with my own, is to underscore that I and my predecessors, Martin Scheinen and Ben Emerson, have been highly critical of the counterterrorism space regionally, nationally, and globally. I would underscore that these spaces are large, they're unwieldy, they're legally imprecise. We do not have a globally agreed definition of terrorism. And they are undergoverned, including within the UN system, where the governance of CT itself remains exclusive of human rights, and it's also exclusive of civil society. So these are not spaces that are open and contested spaces. I think it's also important to underscore in this conversation around terrorism and the intersection with sexual violence is that the global terrorism context is a space which is defined in many contexts by abuse. And by abuse, I'm particularly thinking of national definitions of terrorism. We have in most countries in the world, in the context I work in, definitions of terrorism that are so wide and so extraordinarily imprecise that they cover a range of acts that are legitimately protected under international law. whole areas. Let me just recently call to mind the legislation in Hong Kong. Whole areas have been defined as counterterrorism contexts by virtue of large-scale protest. So I just encourage really hesitant thinking about the dangers of working in the space and the challenges of abuse that lie in this space. I secondly want to stress a theme that I think has come up, as I've said, in all of which is the need for prosecution. And I have in my most recent report to the General Assembly, which was issued just last week, focused on the importance, I'm sharing it with you here, on the importance of the interface between counterterrorism, international humanitarian law, and human rights, and particularly focused on the need to address the range of crimes that can be addressed and the failure in the context that we're talking about to apply international humanitarian law adequately, and the range of crimes, including crimes against humanity, genocide, and war crimes, to crimes that have been committed, including crimes of sexual violence, and thereby undoing or responsibilities to victims. I would also say that a really important piece of thinking here, I think also underscored by some of the comments from Nigeria, are to focus on the scale and the effects of counterterrorism, of sexual violence committed in context of counterterrorism. That is to say, in the securitized and unaccountable enforcement of counterterrorism nationally, regionally, and globally, including the bloating of security sectors and the specific exclusion of liability for state actors who commit any acts in context of counterterrorism in much counterterrorism legislation, that we see an enormous deficit of accountability, including for sexual violence. And my forthcoming report to the Human Rights Council in March 2021 will be looking closely at this issue. I would also just close by reminding us of what a complex space this is, which we all know, but to say that in particular, we have to pay close attention to the conditions conducive to violence, including the gendered recruitment to these kinds of organization, including the masculinities that drive and propagate certain kinds of violence, including violence against men. And not to forget that in this space, we also have to think about the sexual and gender-based harm experienced by men and the lack of accountability for that. So I'm going to close there and turn back to Chloe, appreciating all of the complexity of the intercessions by all of our excellent speakers, and also just maybe to have a little bit of a warning flag on what it means for us to be pushing accountability into the counterterrorism arena, and to think really carefully before that's the move that we make. Over to you, Chloe.
Thanks, Fionnuala, for such a great moderation and for giving us some last thought and a word of warning. I think it's always in terrorism-related business quite important to do so. I also want to thank all of the other panelists so much for their intervention. I think this was extremely rich, and it gave us quite a different vantage points, bringing in the voice of all types of practitioners looking at the issue in a very different light. I think this was enlightening. I certainly learned a lot. It was also thought-provoking and rather inspiring in terms of, this gave us much to think about, but also quite a number of leads in terms of where we need to invest and continue to work on. I also want to give a big thank you to the School of Transitional Governance of the European University Institute for hosting today's debate. And I want to let you all know that we will be hosting with them and with UNODC in next June a seminar on gender dimension and women's rights in terrorism and counterterrorism context. And so we hope you can join as well. Today's session will become available as all the other digital dialogue sessions on YouTube and on the Team of Experts webpage shortly. And we will be continuing this series of webinar next month And our next session will address the issue of accountability efforts for sexual violence and conflict in Central African Republic. So please do stay tuned for more information about this event on our page. And we hope to see you in our next dialogue. Thanks again to all of our excellent panelists today and to the audience for attending this digital dialogue. And we hope to see you soon. Have a wonderful day.